It's Thursday, August 20th, and the tech story that we want to comment on today, and we want to make this comment with reference to another video that we recorded and published this week, and that one was on another case, another legal case with a different dynamic, and that legal case involved Apple and Epic. In this case, we're talking about Uber and Lyft, and a judgment based upon a California court that Uber and Lyft needed to immediately transition their contractors to the status of employees. Anyone who has followed Uber and Lyft since the beginning should be aware that the gig economy principle of independent contractors working even on a daily basis is fundamental to the business plan of both of these companies. So they effectively acted on an ultimatum. And in the world of negotiation, ultimatums are a final level of communication between two parties where if you don't do this, then this is what's going to happen. And anyone who's involved with negotiation is aware that an ultimatum is the last thing that you want to do in any kind of a situation. So in this case, Lyft did act on an ultimatum, and they decided that if this is going to be the case, in other words, the judgment of the state of California would stand, they were just going to pull up and stop doing business in the state of California. Threatened as the Lyft announcement intended, the state actually relented and backed off and made a decision, as is stated here, that a California appeals court on Thursday avoided a shutdown of ride-hailing services Uber and Lyft in the state, effectively handing a decision over gig workers' benefits and pay to voters in a November ballot measure. So in this case, it was very smart move on the part of the Lyft legal team to challenge the state's judgment in the form of articulating an ultimatum. If this is going to be the judgment, we're not going to do business in this state. In contrast, the Apple case, in our opinion, should be handled by compromise. On a daily basis, there are announcements of new parties jumping on the bandwagon to challenge Apple's App Store and its cast in concrete policy of charging a 30% commission on any transactions. The latest and greatest to do this include the New York Times and other publishers who jumped on this case today. In that case, in the case of the Apple Epic caper, we don't think it's smart for Apple to be fighting a shootout at the OK Corral, as we've actually phrased it in one of our recent blog posts. Rather, we think that Apple has to wake up, smell the roses, and make some compromises. The situation is very much akin to the situation of AT&T, who in the late 60s, I believe it was, after a very, very long antitrust case brought on them by the U.S. federal government, actually broke itself up into these regional Bell operating companies. So AT&T also had a walled garden, but they ultimately speaking, the government won that case. We think ultimately the size of the iOS community is such that Apple isn't going to win this, and they are going to have to do some compromise. So that's our opinion for today. We work with C-level executives at early stage tech companies as well as CEOs from an advisory perspective. If you would like to chat with us about what you have on your mind, please don't hesitate to contact us. My name is Ira Michael Blonder. I'm the CEO and founder of IMB Enterprises. And check us out as well on Twitter. My Twitter handle is Mike the Bebop. Thanks.